All right, so we just started the recording, and again, thank you guys for joining me today for this forms deep dive. Today, what we're going to be talking about, I'm going to share the screen here, is, let's see, if we go to SkySlope. So I'm going to do a couple of things, and just as a quick reminder, since this is live, if you have questions or comments, I absolutely welcome those. It's important to making this as valuable as I can for you. However, when I'm sharing my screen, I can't see you raising your hand at me. So unmute yourself and interrupt me and ask a question if you have a question, okay? Because I have to minimize all the screens in order for me to navigate the fields in the forms and everything and share the screen with you. So we're going to start talking, first of all, with some of the basic stuff, the exclusive right to sell listing agreement. One of the big things that came up in the training, when I say training, the UAR convention last week, is who is the seller? Okay, and if I click on this, I can put the first name in, last name, whatever, and then I could add another person as well. But who is the seller? Stop sharing my screen so we can have a real conversation about this. Folks, this can get a little bit crazy. Okay, let's say that the seller is a trust. Okay. Anybody here have trust set up? Okay. Alan, you're the trust, or you've got a trust. Who's the trustee?
Me and my wife.
You and your wife. Okay. So let's say that you and your wife sign just as you and your wife.
We did not agree to that contract because the trust owns it. We got to sign as trustees.
Yeah. Did you guys know that?
Or if just I sign it, then
Yeah.
we're not binded. We're not bound.
So let's simplify this. Let's say that the trustee is just Alan. Okay. And Alan signs as himself, right? So if we look at title, it says the Alan Blood Living Trust Account. That's who owns the property. But Alan is signing everything as just Alan Blood.
Alan Blood.
Do we have problems? What do you think? Who would have ever anticipated that? They actually had this go to court, and somebody got to the end of a deal, decided they didn't like the terms, and they basically told on themselves and said, well, you don't have a valid contract because this was supposed to be done and signed by the trustee, and instead it was signed by me. So this isn't a valid contract. You can't enforce that contract on me anymore. And they said, well, you are the trustee. Well, I know, but you don't have any record that that the trustee instructed me to sign on their behalf. And again, I mean, does that make your brain melt or what? And that person won in court. That went to court, and they won because there was no recorded written instruction from the trustee to Alan Blood to sign on behalf of the trustee, who was Alan Blood.
It wasn't me, by the way. I did not go to the court. Let me ask you a question, Eric. I see this fairly often, and it's a problem for financing, but I don't know what you think about it. Agents will put on a contract owner of record instead of going and finding out who the actual owner is. What's your thoughts on that?
So sometimes we do that because we don't know who it is. Maybe our internet's crashed. We've got a piece of paper in front of us. We don't know who the owner is. And so we put owner of record on there. You have to have an addendum later on directing that or clarifying that. So that's the only time you could put owner of record on there, because maybe you don't know who it is. But no, that's not going to be enforceable later on. If somebody wants to find a problem with that contract, that'll be a piece of cake for them to tear that thing up. So yeah, eventually you would need to add an addendum identifying clearly who the owners of record are. Is that what you're seeing from the underwriters?
Yeah, that exactly. But I guess that brings up the same issue. If you have owner of record and they've signed it and it wasn't really the person who needed to sign it, you don't have an enforceable contract until you have that addendum. So you're leaving yourself open to the seller having a change of heart or whatever, I guess.
Correct. So if you put in owner of record and somebody signs it who isn't actually that owner of record, that's not a valid contract. Okay. So I'm going to go back to sharing the screen with you. And I just want you to understand that even these small details, that's why when we do a deep dive, we can spend 10 minutes on a discussion over who is the seller. You're not going to get this in any real estate courses, but these kind of details matter. So when you check out title, or, you know, if you're working with, in this case, this is the exclusive right to sell listing agreement, you definitely want to make a quick call to your title company. Some of you have apps with your title company where you can check really quickly and see who the owner of record is. And then if it says a trust, anything like that, another common issue that comes up is it's a divorce situation and they're needing to sell the home, and you meet with them and they say, yeah, I have permission to sell this. This is my house. I have full permission to sell it. You need documentation for that. Okay. You can't take anybody's word. So if it's a trust, you're going to need a copy of the trust. If it's a divorce scenario, then you're going to need a copy of the signed divorce decree signed by the judge. All right. Not just an agreement, some kind of a temporary agreement between them. In a divorce situation, it does get signed off by the judge. Even if you agree in mediation, they take that mediated agreement and send it off for signatures so that there is something official. And if one person does have the right to sell it, but two people are on title, but one insists they have that right to sell, then again, we're going to need documentation to support that, because otherwise all we have is what's on title. So just make sure that you do your due diligence and find out who the seller is. I once had an agent list a home and work trying to sell it for, it was about 6 months, and he never checked title. And it turned out that these were adult kids. They were in their 20s and they'd gotten married and they were living there, but they were not the owners. It was the parents that owned the home. Every once in a while, you'll find a tenant who doesn't quite understand how the world works, and they're trying to sell their landlord's property. It's usually confusion on their part, but that's why we're professionals, is we shouldn't be pulled into that confusion. Okay, we should be identifying these things up front very quickly. So rule of thumb, always check title beforehand and make sure if it's a trust, you have a copy of the trust and you know who has permission to sign, and make sure they're signing as that person. So if it's a trustee, it's Alan Blood as trustee. And if you're not quite sure how to have them sign it, because I never remember. Okay, so the easy rule is I call my title company and say, all right, I've got the Alan Blood Limited Trust or whatever it is. I've got this Alan Blood Trust, and Alan Blood is the trustee. How does he need to sign papers at closing? Because how he signs papers at closing is how I need to have the whole contract signed. All right. And so if you guys can't remember all the details, like if somebody has power of attorney, if I have power of attorney, I can't just sign Eric Lee. I have to sign Eric Lee as power of attorney for Alan Blood. Alan,
something I'd add to that, Eric, if you're listing the property, if you think it's appropriate, ask the sellers for a copy of that trust and make sure your title agent has it, because then they can answer those questions for you and for the buyer's agent. That trust will eventually be needed by a title company somewhere along the line, maybe even the underwriter. So, if you see it's in a trust, get that up front.
Yep, exactly. And I kind of mentioned that, maybe I didn't highlight that as much, but if it is a trust, you need a copy of that trust to make sure that things are done correctly. And not just knowing what name to put in here, but again, how they sign it, because I had never heard, I've been doing this 20 years. I had never heard of anybody signing as themselves when they are the trustee and having that be invalidated in court, because it's an absolute mind melt to me. But trusts or divorces, you want copies of the divorce decree, copies of the trust, because eventually you're going to have that for the title company. If it's somebody's passed away, okay, then we might need what are they called? The death decree. What are those called?
Death certificate.
What's that, Martel?
Death certificate.
Death certificate. Thank you.
I thought I was
So-
muted. Sorry.
No, you're fine. So we might need a death certificate as well. So just make sure that if you see two people on title, but only one of them are signing, we need to have documentation to support why that one person can sign. And again, if it's power of attorney, something like that, they need to be signing as a power of attorney. If they're a trustee, they need to be signing as a trustee. All right. Next, you've got yourself as the seller's agent. One of the big challenges that I see here, we have a saying in the industry, and I don't know if this is saying that you guys are aware of, but brokers are all aware of this. And it's a saying that is realtors don't read. Is that just with brokers, or have you guys all heard that? Okay. It's not disparaging, but it is unfortunately reality that realtors don't read. And so things change over the years, forms change. And it's really interesting how little things in the forms can totally change the whole dynamic of it. Okay, one of those, for you agents that have been around for a long time, I still see mistakes being made. Right here, I heard of one just was it yesterday, maybe 2 days ago, where their effective date was today because they didn't read. And if you went back 5 or 6 or 10 years or something, the term of the listing used to be from now until whatever date you put in here, or sorry. You click on anything here and it pulls up a field. But no, it used to be starting on today and then it would end some other time. Okay. So anyways, what they've done here is this ends at 5 p.m. on this date. And for people that have been around for a long time, they used to put in their starting date here. And so if you're not reading that this ends at 5 p.m. on this date, and you're putting in your starting date, you effectively have a 1-day listing agreement. Or if you signed it in the evening, you don't have an any day listing agreement. Your listing agreement is ended before it's even begun. Okay. So if you're a new agent, you're not sure how long of a listing agreement you should put down here. Typically, we would do 6 months. However, if it's a big ticket listing over $1 million, something like that, quite often those will be a year, because you're putting a lot of people will put a lot more money into those listings. They do take longer to sell, and so they'll do a year-long agreement. I've seen a listing agreement that was 2 years. That actually came up in court because they said that that was an abnormality, and that most agreements, they said in court, most agreements were like 3 months. And that agent was operating outside of the norm to do a 2-year agreement. But the judge actually upheld it, that 2 years was okay. Everybody had agreed to it. All right. Here's another thing that I want to point out. In the event this listing agreement expires while the property is under contract to be sold, the company and seller mutually agree that the listing period shall automatically extend until the under contract transaction closes or is canceled. So if this goes under contract during the listing period, it's automatically extended. You don't have to add an extension to your listing agreement. If I go under contract December 15th, I'm obviously not going to close till maybe January 15th, but this expires on the 21st of December. I'm okay because of this language right here. It's going to automatically extend, and I'm covered for this brokerage fee and everything else till I get down there. Now, here's the part that I want to really point out. Okay, when we get to this brokerage fee, there are a couple of class action lawsuits, major lawsuits, that if they shared the numbers with us at the convention, if these numbers came through, it would shut down, bankrupt basically every major brokerage across the country, because Realogy is one of those named, and they own almost every major name that you can think of. Okay, so one of the cruxes of their argument is that buyer, and I'm going to stop sharing here because I have to look at you guys to make sure that you're understanding the importance of this. This is kind of a change over how we did things. And a lot of the way that we talk, the way that we present ourselves, I've had to go in and change presentations. I've had to delete old presentations that I had on YouTube because they could have been considered in violation of this. What it was as buyer's agents, we were going out and telling everybody, hey, it doesn't cost anything to use me. Right? We did that a lot. It doesn't cost anything to use me. My services are free. The problem with that is, number one, it's not true. Okay, you're not working for free. You do expect to be paid. You just might not be paid by the buyer's agent. So the crux of these arguments, and there's two different court cases going on right now, both of them in the billions, one of them into the hundreds of billions of dollars. That's billions with a B. Okay. It's not something even these major companies could absorb or pay out. This is more, potentially more. You remember the big tobacco lawsuits that happened years ago, and they took 20 years to pay off? This is more than those as a dollar amount. And so what I'm trying to drive home is this is serious business. So when you're talking to people and you're a buyer's agent, your services are not free. Okay, that's a real simplistic way of looking at it. It's not totally correct. It may be free to them, to that buyer, but it's not free. And so being honest in how you present that becomes very important. So when we present this to people, we do get paid, and we may not be paid by the buyer's agent, but we need to go into detail we need to look more in depth at that buyer's agent commission section. And I'll go to the exclusive buyer broker agreement here shortly. But this change that I'm showing you right now on this form, if I share my screen back to the form, I like to make eye-to-eye contact when things are really serious. This change down here is new as a result of this class action lawsuit, because it says right up front, and one of the arguments was the seller's paying this fee, that's inflating things, and they're not aware that they're paying this fee. And so we're pointing it out that they're very aware of this now, and they actually have a separate initial spot down here by this. So this is something new just in the last year. If you're a new agent, this is all you know, but for you experienced agents, this becomes very important because it has ties back to that major lawsuit. So the things that I want to cover in here. All right, we've got our brokerage fee. It's very important that you understand that you're putting in here the full amount. So if you're charging 6% as a listing agent, maybe you're thinking, but I'm only making 3%, so I'll put in 3 here, and then you say down here that you're going to offer a buyer agent of 3, then you just worked for free. And I see this happening to agents. Okay, you just put in a lot of work and your own money, and by contract, which extends to by law, then you can't get paid anything more. All right. So make sure that this includes your commission and the amount that you're going to be responsible for paying out, because this company, that's us, we're going to offer a buyer's agent commission on the MLS of 3%. So we need to collect 6% so that we can pay you your 3 and have enough to pay them their 3. All right. Sometimes I get the question, can I sue these people for a commission? So let's look at that, because this is basically what we would be enforcing. And usually this question comes up because we've gone under contract and they've changed their mind and decided not to sell. And usually sometimes that will give penalties to the seller because they've breached the contract, the purchase contract. And so they're going to be paying those penalties. And usually we want to say that there could be potentially other penalties with us, with the brokerage, because they're not aware that by canceling this, they're not just losing the $1,000 earnest money, but we could potentially go after this full 6% commission. That's usually the argument that agents are bringing to me. And they say, can we sue these people? Because they want to hold their feet to the fire a little bit and get them to perform on this contract like they've signed and said they would do. So let's go over this. All right, the brokerage fee shall be due and payable from the seller's proceeds if it's purchased the date of recording of the closing documents for the acquisition of the party. All right, so that's if it actually closes. If it's a lease, the effective day of the lease, or if it's an option, the date the option agreement is signed. Now, if within the listing period or any extension of the listing period, the property is withdrawn from sale, transferred, conveyed, leased, rented, or made unmarketable by a voluntary act of seller, meaning that, an earthquake didn't happen and trashed the home and now we can't sell it. That's not a voluntary act of seller, so they couldn't be held liable for that. But if they made a voluntary act, they just decided to pull it off, okay, without the written consent of the company, or if the sale is prevented by default of the seller, the brokerage fee shall be immediately due and payable to the company. So if somebody breaches contract, that's a default. The brokerage fee could be immediately due and payable to the company. The company is authorized to share this brokerage fee on the MLS with another participating broker. And we're going to offer this 3% buyer agent commission. This amount may be modified only with the consent of the seller. So if you change this, you need to add an addendum to this agreement, changing that. And then this bold, this is directly from that lawsuit. Brokerage fees are not set by any board or association of realtors or MLS or in any manner other than between the company and the seller. All right. So let's talk about reality of suing your clients. Okay. You could mention to them, hey, there may be some penalties here, but folks, how many of you have had experience playing in court? Anybody, Alan, have you not gone to court for anything? You're an attorney even.
Gone as an expert witness for other people's problems, but none of my own.
Okay. I've been as an expert witness as well. Has anybody actually had experience in court in this group? Going to plan?
Being the defendant or plaintiff?
Just either one. Okay,
I've
here's
been a
the,
witness, but I've never had charges against me or
okay. So here's
charged
the thing.
anybody.
Last time I was an expert witness, it was over $5,000. Okay, the buyer sued the seller for $5,000. The seller countersued the buyer for I think $20,000. There, it went for 2 years for $5,000. It went for 2 years in court, over $40,000 in attorney's fees. So when agents come to me and they say, hey, I want to sue this person. First of all, can we? If we look at that contract in this scenario, yeah, it was a seller default. We could hold their feet to the fire a little bit. What is the reality though? The reality is lawsuits are extremely expensive. Okay, extremely expensive. The court system, the legal system is challenging at its very best. At its worst, it's absolutely infuriating, and you will feel like you have just stepped into the twilight zone. There are so many different things that an attorney can do to stall things, to drag things out. And first, and the other thing that you need to understand is when you sue and people engage an attorney, one of those attorneys' very first things that they do is they instantly look at countersuing. And so they will go through that contract with a microscope. And if they found mistakes that you've made, you may have violated your fiduciary duty to them, and they're going to countersue you because you weren't really looking out for them. They're going to look for any little flaws, any missed initials, missed signatures, things like that. And they're going to come back at you. And the tactic for that is very simple. If they make it painful enough for you to continue with this lawsuit, then you'll just back off and go away. But not only that will they go after you, they'll go after me, the brokerage, the broker. A lot of times they just name everybody that they can. Again, the goal is let's make this painful. Okay. So when you come to me and you say, can we just sue them? The answer is yeah, possibly. Okay. But is it a good idea? Rarely. Now, again, I've been an expert witness. We've been called in to do these things. And very, I need to make a quick point. You can't sue anybody. It's the broker that has to place the lawsuit. So an agent can't sue somebody. The brokerage has to. So anyways, that's the reality of it. The other, if you've really been wronged, I'll have your back. Okay. Like I said, we've done this before. We've successfully sued for commissions. We can help you. Just know that it's not easy. And if it's anything less than $10,000 or $15,000, you're almost going to break even, almost guaranteed in attorney's fees versus what you get for your commission. Okay. So that's the ugly truth of it. Do the contracts hold up though? Yes, they do. These contracts are well written, and that needs to be driven home because the contracts will hold up against you as well. All right. So not only will they hold up against the other person, they'll hold up against you if you violate your fiduciary duty. So let's jump back to our form. Man, we're going to spend a whole hour just on this one form. All right, we've got our protection period next. This is how many months after termination of this listing agreement, if it's acquired by any property to whom the property was offered or shown during the listing period, then we'll still get paid. So even if this was showed to somebody during the listing period and they decide to make an offer, let's say that we put in 3 months here, they decide to make an offer a month later, then we get paid. The reason this was put in here is to kind of discourage people from saying, you know what, thanks for coming and seeing my home. My contract with this agent actually expires in a couple of weeks. If you want to just wait a couple of weeks and make an offer, then we can cut him out. I really think that's why this is here, because I've seen that happen a lot. So this protection period helps with that. However, what it doesn't help with is, hey, my listing expires in a couple of weeks, and I really don't love my real estate agent, so I'm going to hire somebody else, because we've got this line right here. Unless the seller is obligated to pay a brokerage fee to another brokerage based on another valid listing agreement entered into after the expiration date of this listing agreement. So if this listing agreement expires and they sign a new agreement the very next day, this protection period is effectively 1 day long. All right. Yeah, Joe.
Question.
Yeah.
In the past, and I'm not sure what Utah requires, but in the past, I've always given a list of people I've shown the property to. So I have documentation that these people did indeed see the property during my tenure as the agent. Is that required?
It is, again, it would depend on, I actually haven't heard of somebody doing that. I don't think it's a bad idea though, but it would depend on what they're doing. If they are listing it with somebody else, then it wouldn't matter. Okay. If they just decide they're going to take a break and you're suspecting that that's not really what they're doing, they're going to be working something on the side, then absolutely. You could provide them with that list, say, hey, this is everybody that saw the home while I had it listed. And this is referencing this protection period in our contract, just so that you're aware. Okay. So if
Okay.
you think they're not being honest with you and they're just wanting to end let the agreement expire and work with somebody else off the side, then by all means you could provide that, and that would let them know that you have taken this seriously, and they could reference this part of the contract, and maybe they would re-examine their intent.
What if they relist with another agent and those same people whom I had spent time and showed the property decide to make an offer under the listing with the other agent? What is our position at that point?
The contract is pretty clear on that. If there's another valid listing agreement in place after the expiration or termination of this protection period doesn't apply.
Okay,
So if they've signed with somebody else, then you're done.
okay.
Okay. All right. This next
Thank
part
you.
becomes important based on our earlier conversation. And again, it's some protection for the agent, that the seller says that they are all of the record owners of the property. So the people signing here should be all of the record owners of the property. They warrant that they have marketable title and an established right to sell, lease, or exchange the property, and they agree to execute the necessary documents of reconveyance. They're going to furnish the buyer with good and marketable title and pay a settlement for a policy of title insurance, which again is reiterated in the purchase contract. And they're going to fully inform the seller's agent regarding the seller's knowledge of the condition of the property. That means they're going to fill out the seller property condition disclosure form. All right. Upon signing of this listing agreement, the seller agrees to personally complete and sign the seller's property condition disclosure form and wire fraud alert disclosure. So both of these need to be signed right up front. And then the seller agrees to indemnify and hold harmless the seller's agent and the company against any claims that may arise from the seller providing incorrect or inaccurate information regarding the property, the seller failing to disclose material information, okay, including a whole bunch of stuff, and any injuries resulting from any unsafe conditions within the property. So there's a lot of protection in here for the agent, and that the seller is going to personally complete and sign a seller's property condition disclosure form. So the question came up at the convention, what if somebody submits to you the old seller property condition disclosure form? 6 pages versus 15 pages. Okay, what do we do? Is there
Yeah.
liability? Let's start with this. Is there potential liability for you as the agent if your seller does not fill out the correct disclosures?
Yes, I would think so.
Okay, and when I say correct disclosures, the UAR provided disclosure form of 15 pages. Okay, why would there be liability for you?
Because we're the experts, we're the professionals, and we should know that they need to complete the updated forms to be in compliance, is my opinion.
Okay, so let me go to another question then. And I'm just trying to cause you guys to think a little bit here about how things work a little bit. Is there anywhere in the purchase contract or in this agreement that says we are using the UAR provided forms?
No.
No. If we go to the purchase contract, it says that we're going to provide a seller property condition disclosure form, right? If I share my screen, I go back here. We're going to jump over to the real estate purchase contract. Let's go down to seller's disclosures. Okay. A written seller property condition disclosure for the property completed, signed, and dated. Now, this one isn't all caps. Okay. Down here, it is all capitalized, a seller's property condition disclosure form. Okay, but does that specifically mean that we're using the that actual form from the UAR? Joe?
No.
It doesn't specify the specific form, but I would think utilizing the new form protects both the sellers and the agent, listing agent, and potential agents down the road, because the buyer's agent, because it has more clauses and more protection and more disclosures attached to it that clarify other points. So
Okay.
my opinion is it keeps us out of court.
Okay. I'm not disagreeing with you. I just want to make sure we understand why these issues. Vicky, did you have a comment?
I did. I have a house under contract right now that I'm the listing agent on, but the seller's disclosures were filled out prior to the change. And it's a new home. So do I need to go back and have them fill out the new seller's disclosures on it?
I'm gonna go into this topic a little bit more, and I'm gonna let you answer that in just a bit.
Okay.
All right, let's talk about protecting you as an agent. Okay, let's say that somebody, because there's a written seller property condition disclosure could be an 8.5 by 11, and they hand out a few things that they knew was wrong with it, right? There's nothing that says you have to use the UAR approved form. There's nothing on this contract, the exclusive right to sell. There's nothing in the real estate purchase contract that says that. However, the chances, as Joe said, of there being confusion, information that was missed, something like that, those chances skyrocket if I'm handwriting that out, right? So if there is a lawsuit later on and my seller gets sued for failing to provide all of the information that they were aware of, which they certainly would have, I mean, there's a whole bunch of things you don't even think about unless you've got that form kind of prompting you. So my seller gets sued. And again, I'm going to take you into the real ugly world of lawsuits. Seller gets sued, and it's usually for a significant amount of money when it's lack of disclosure, because now people need to do new roofs or dig a new well, and all of these things cost a lot of money, enough that everybody's getting attorneys. So the seller gets an attorney, and that attorney, who's he trying to protect?
Seller.
The seller. What about you, the seller's agent? No, he has no interest in protecting you. In fact, you may be the scapegoat here. You may be the golden key, the golden ticket that gets his client out of trouble.
Right.
So he goes to his client and he says, why did you use this form? Well, I didn't hear of anything else. Okay. If it goes to court and they bring in an expert witness and they put me on the stand and I'm an expert witness and they say, hey, Eric, how do you typically do seller's disclosures? And I'd say, well, the UAR prepares all our forms for us, and they've got this great 15-page form that asks all of these questions. And then that attorney would say, if you go to page 3, does it talk about this? And I would say, yes, it does. If you go to page 5, does it talk about this? Yes, it does. If you go to page 7, does it talk about this? Yes, it does. So why would an agent not give their client this form? And I would say, I don't know why. Does that look bad for that agent? Because now they have not operated according to a basic standard of service that that would be expected of most agents. So when you go in as an expert witness and you say, this is the basic level of service that every agent gives, and yet my agent didn't give me that level of service, my agent looks bad. So if we're using that old form, Vicky, and this for some reason goes to court, and an expert witness comes up and says, but on page 8, and you've only got 6 pages in your disclosures, but on page 8 of this one, 9 of this one, 11 of this one, you've got extra things or extra space. How come you didn't use this new form? What do you think?
I think I need to have them fill out the new form.
I would do it.
Okay, perfect.
So great. I'm so glad that you guys are coming on here, because catching that could be worth this whole hour. And you're not the only one. This comes up very common. Okay. Catching these little things can save us a lot of grief. So we've got the seller's disclosures form. What if you are what if you're the buyer and the seller doesn't give you the 15-page disclosure? They give you the old one, or they give you an 8.5 by 11 with some notes on it. What do you have the right to demand? Can you demand that they give you the 15-page one? Is there anything in the contract that forces that?
There's nothing that forces it, but as a buyer's agent, we would want to have everything disclosed. And then it comes back on us if the buyers find something that should have been known and disclosed, and it would have been on the 15-page.
So how is the proper way to do it? Because we can't demand it. There's nothing in the contract that we can go to that says you're going to be in breach of contract if you don't provide us this UAR approved 15-page form. There's nothing in the contract that says that.
Very diplomatically with the seller's agent and explaining to them that, you know, this is needed and this will help us stay out of court, and with all this other information to protect everybody and involved in the transaction. But
and the
just
seller's
be very
agent mysteriously
diplomatic.
says, I think we're good with the 6 or 7 pages. I talked to my broker. They think we're good.
Eric,
Yeah.
tell them that your buyer has requested a more comprehensive review or disclosure.
Okay.
And
One of
then
the things, go ahead.
I was just gonna say, and then get it, in writing if they say we're good.
Yeah.
Yeah.
One of the best ways to protect yourself here, if you're the buyer's agent and you got the old 6-page form, sit down with your buyer with the 15-page form and the 6-page form. Go through each of them, and things that aren't covered adequately, you can then go back and say, you could try to go back and say, we would prefer the 15-page form. Can you fill that out and send it to us? And if they say, no, our broker says we're okay with just this old form, since it was listed, 4 months ago when the old form was still there. Now you're sitting down with your buyer and saying, here's the things that form left out. Would you like this information? And then we email them because we want paper trails of everything. And we say, we've sat down with our client and looked at the 15-page form, and the information that you gave us doesn't cover this, 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 and this. Could you give us more information? So just what Rebecca said, but you can use that 15-page form as kind of your roadmap. So that if this does come up later on and there is a lawsuit and attorneys are called in, you get to sit there and say, yes, I did go through the 15-page form with my client. I did do my fiduciary duty. This is the standard of practice. And we went through all of this, and all of that makes you look like, hey, I really did know what I was doing. I talked about my client, and then everybody's focus goes on that agent or that broker, saying, look, everybody here in this room knows what should have been done except you. But if they can peg it on you, the buyer's agent, they have no problem. It doesn't dilute the lawsuit to have more than one person get named. Okay, that's just more people to charge. Everybody pays. All right, but you want to be so squeaky clean that all the focus shifts off of you and onto that other party. Joe, you had your hand up.
Yes, I did. I have a question. So I think it's very important to do a home inspection. So with the home inspection, if there's a good inspector who's thorough, would that kind of help cause the sellers to readdress some other items? But I like that idea of sitting down with the buyers and all going over the two documents.
Okay,
and
yeah.
emailing. But what about the home inspection? How does that play into this?
I'm going to jump over to the home inspection, and I don't know if this is exactly what you're saying. Of course, when we're doing,
No, I mean, as far as the seller's disclosure or.
yeah, when we're
lack
representing buyers, first of all, we're always going to recommend a home inspection.
Right.
But let's look at the seller's disclosures. Okay, no later than the seller's disclosure deadline, we're going to provide a written disclosure. All right, lead-based paint, all of this stuff. And I don't actually have the seller's disclosures here. Let's see if I can add. Let's see.
I like the new one. It's really comprehensive.
Yeah. Okay, let's pull that up. So let's pull up the seller's disclosures and let's read this first little bit. All right. Seller is obligated under law and under Rep C section 7A, which is that disclosure section, regardless of occupancy. And I get asked that question all the time. My
Right.
client's an investor. My client never lived here. It's their parents live there and their parents passed away and they don't have a lot of knowledge of the property. So regardless of occupancy, they're going to disclose to buyers defects in the property and facts known to seller that material and adversely affect the use and value of the property that cannot be discovered by a reasonable inspection by an ordinary prudent buyer. This disclosure form is designed to assist the seller in complying with those disclosure requirements. So this is a legal requirement right here. And I'm going to stop sharing because I want to make sure that you understand a couple of quick points. And it's important to understand that we have a contract requirement, but there's also a legal requirement under Utah state law, and they aren't the same thing. Okay, for example, can I add an addendum to this contract saying that no disclosures will be provided to the real
If you
estate
want to
purchase
end up in,
contract?
if you want to end up in court or get sued and accept liability, you can, but not according to the law.
Okay, so what does because the contract is the one saying I have to provide it. But what a lot of agents don't realize is that there is a law on the books for Utah that says that you have to disclose any material facts that you know about that property. That's totally regardless of what the contract says.
Right.
You have to disclose material facts that you know related to the property. So can I add an addendum saying that if I go back to share my screen, let's see, there we go. And I go to the real estate purchase contract and jump down to the disclosure section. Can I add an addendum that says section 7A does not apply and seller's disclosures will not be provided? Now, granted, if it's prior to 78, I'm going to still have to provide a lead-based paint disclosure because it's required by federal law. Going to have to provide the title commitment for title insurance. So I can't block out all of this, but I could do 7A. What are the conditions that I could do that in?
Maybe if it's a brand new home and there's builders have their own disclosure of everything that's in the property and they have the warranty for a year, maybe, but that's the
Okay.
only thing I could think of that would even come close to having that waived.
Okay, now banks do this. I just saw a HUD property get accepted this morning. So
Oh.
I get notified as principal broker when HUD properties start flowing again. We just had
And they're going
one of our
to.
agents just won a bid on a HUD property. Do banks provide seller property condition disclosure forms?
No,
Why not?
because most of the time, they've never even been in the home.
Okay,
They've
when we
only
say
s-
they, the bank is not a
Fannie
person.
Mae, the bank is an entity.
Yeah, the bank's an entity. The bank cannot go and visit that home. There's some employee on the other side of the country pushing papers around. So can they truly say they don't have knowledge about the home?
Yes. They can, but a lot of them in the past have contracted with agents and the agents go out and provide them an inspection report.
In which case, even with HUD properties, they tell you that they know that things are wrong with it. Okay, so what is the only time you can addend the real estate purchase contract and say, we're not going to provide seller's disclosures?
Well, Eric, I think that if you addend it and both parties agree, which as a buyer's agent, I wouldn't expect my buyer to waive that right. But if both of them agree, is that enough to, I guess I'm saying if it's an agreement on an addendum and both sides agree.
It's not actually. And this is one of the things that I asked the attorneys up there, because I've had this question come up, Rebecca, and I may have given wrong advice in the past. Okay. But I did ask this question directly to the attorneys. And this is where they made it very clear that there is a Utah state law that you cannot contract out of. Okay. So there is only one instance where you can addend the real estate purchase contract to not provide seller's disclosures. And that instance is when they have no material knowledge. Those are very, very rare circumstances. My parents' home. Have I ever lived in it? Yeah, actually. After my first marriage fell apart, I lived with mom and dad for 3 or 4 months. Okay. I've gone over there for Thanksgiving. I've gone over there for Christmas. When their home flooded, did I know about it even though I wasn't living there? Yeah, they told me about it. It was a pain. They had to set up the fans and I visited them. They showed me how well the company had done the sheetrock. Do I have material knowledge about that home even though I've never lived there? So if my
Yes.
parents passed away and this home goes through probate and I have to sell it and all the kids get together, do we have knowledge even though we haven't lived there? This is not the family home we were raised in.
Yes.
We do. We have material knowledge and we cannot contract out of that to not provide disclosures.
Right.
All right. A builder, does he know things about the home? Yes, he has material
Absolutely.
knowledge. Okay. A flipper, does he know things about the home? Absolutely,
definitely.
100%. A long-term landlord, he's held the property for years. Does he know things about the home? Bet your
Sure.
ass he does. He's never lived there, but every time a light bulb goes out, he gets a phone call,
Right,
right?
right.
So if you have material knowledge, you must disclose it under Utah law. We're not talking about the contract here. This is Utah law. Okay, the contract states all those different things to help us provide the correct information, right? Because all of those things listed, the title report, that's material information about the home. By law, that's considered material. Material, by the way, is a term that says if it were important to somebody to know that could possibly affect their decision to purchase it or affect the value of it, the purchase price, that's material. Now, Utah law does clearly say that a few things aren't material as defined by law. And this is different in Utah than it is in California. If the house is haunted, is that material?
You don't have to disclose that.
Not here because it's defined by law. It's not a material
Right.
fact. If somebody was murdered in the home, that's not a material fact because the law says it's not a material fact.
Right,
Somebody's opinion could be like, well, damn, I would have wanted to know that. That does affect the value to me. That does affect my desire to purchase it or not. But law comes in and says, nope, this is not subjective. We're going to define this as not a material fact. But in California, it's not the case.
for 3 years.
Yeah. So understanding how the law works becomes very important. So you have to provide all the material knowledge that you have. The contract says, here's all of these things that constitute material knowledge. Things that happen in the HOA, the rules, the meetings, the notes, the budget, all of that stuff's material knowledge that affects somebody's ability to buy a home. The transfer fees, the reconveyance fees, Alan sees those come up. They surprise people all the time. Some of them are big. You know, you've got 1.5 points for some of those fees.
If you're buying a property in Daybreak or you're representing somebody with a property in Daybreak, oh my goodness, check that because it's 0.75% to 1.5% depending on the community.
And when you're talking a $700,000 home and you're 1.5%,
10 grand is a shocker at closing.
yeah, that's not a surprise you like to walk into. Okay, so we have taken quite a bit of time. I really like the discussion that we've had today. This is the number one reason, and I didn't even plan this, but this is the number one reason agents get sued is disclosures. All right, and clients, by the way. So we've taken kind of a convoluted approach to it, getting into talking about disclosures and all of these things, but I think we've done some good today. And I want to end it because anything over an hour, nobody's ever going to watch the recording anyways. But did somebody learn something new?
Definitely.
Okay, so in that case, it was valuable because you guys are fantastic agents. All right, you guys that are on with me here are agents that care about your business. You're aggressively working at it. You care about educating yourself. A lot of you have been in business over 10 years. Some over 20 years, huh? Right? Yeah. So you guys are great agents. And if we're learning stuff at this stage, that just shows you how important these things can be, how much value you're providing to your client, because these are things that guaranteed agents in their first year of business don't know. So when you go out and you talk to people, you let them know how valuable you are. Make sure that you're conveying this information. We are not Uber drivers. We're not locksmiths that have the magic key to get into homes. We're not people that know how to dance on TikTok. Okay. We are the contract experts that help our clients, that protect our clients, that find solutions to problems that most people don't. And it doesn't matter if they're licensed or not. This is the top 10% right here because you guys care. And you cared enough to come today and learn some things. And I cared enough to go to a convention where I could talk to a bunch of attorneys and bring stuff back to you. And it's this business of caring for people that we're in. So I appreciate you guys caring. Alan, I appreciate you caring enough to stay on with us this whole time and to chime in from a lender's perspective. I think that's great. You know, my original intent was to go over the purchase contract where you have the ability to talk a lot more, and we never even got to it really.
It's super helpful. I every time we do these, I learn something like Rebecca was saying. I didn't know you can contract out your disclosures. That's great. I mean, there's always something new, Eric. You do an awesome job with this. Thanks for letting me be part of it.
Okay. Well, I appreciate you guys joining me. I'm going to stop the recording.